Hello, and thank you for joining us for the TAA webinar, What You Need to Know About Rights Clearance and Permissions, presented by Steve Gillen. Steve teaches electronic media law at the University of Cincinnati College of Conservatory of Music. He worked for nearly 20 years in publishing prior to entering private practice in the mid-1990s. He is presently a partner at Wood, Herron & Evans, a 145-year-old Cincinnati law firm focused on intellectual property, where he concentrates his practice on publishing, media, and copyright matters. Steve is a longtime member of the TAA Council and a regular speaker at TAA conferences. He is also the author of Guide to Textbook Publishing Contracts, Guide to Rights Clearance and Permissions in Scholarly, Educational, and Trade Publishing, and co-author of Writing and Developing a College Textbook, A Comprehensive Guide. Hello, Steve. Thank you for joining us today.
Thank you, Kim. Hello, everyone. Let's get right to it. There's only one person in the photo smiling. The others all look like they just heard something a little shocking, or maybe they just saw a puppy get hit by a truck. You may be wondering what it has to do with rights, clearance, and permissions. Although that might be a little mysterious now, we'll get back to it later. But first, the small print. The disclaimer: what sort of lawyer would I be without this? A lot of words to make a small point. I'll pose a lot of questions and suggest a few possible answers, some of which you can hold me to. But at the end of the day, this is an educational presentation and not an attorney-client consult, and so I'll not be giving legal advice today. The place to start with this discussion is First Amendment to the U.S. Constitution and the Bill of Rights. In the U.S., as a creator, you have the right to say and write what you want about who you want. That's a constitutional guarantee. But if that's all you know about it, you're headed for trouble, because it's just a little more complicated than that. The free speech right is not without limitations. First among them, of course, is a result of our copyright laws, but there are also other limitations at work. With respect to each, you have to spot the issue first and then determine how best to address it. But before we get into the substance of what it is you have to look out for, let's confront this threshold question: whose job is it? As an author, a writer, a researcher, or a producer, the answer is it's yours, as between you and your publisher or producer. Unless, that is, you negotiate otherwise, and you do have an opportunity to do this. And there are at least 5 good reasons to negotiate this rights clearance obligation away. If you're a first-time author, you haven't done it before. Even if you've been an author for a while, it's not certainly your area of expertise, and it's quite possible that what you do know about it came from your publisher, who has either accidentally or deliberately misinformed you about what's required. You don't have the contacts. You don't have in your contact list names of the permissions editors and their phone numbers and email addresses. You don't have a list of sources. You don't know the customary terms or the language in some cases, and in particular with areas like music and photographs. In those industries, the folks who manage the rights clearance and permissions have a language all their own, and the words that they use don't oftentimes mean what you think they mean. And then finally, you may not have the cash. So what are your other options? Well, there are several. First, the publisher can clear the rights and have you pay. And there's good reason for the publisher to take this on. It's the sort of thing that they do much more frequently than you do. They're doing it across a range of titles or articles or productions, and as a consequence have built up a database of those contact names and contact information that are so useful. They understand the customary fees for various kinds of permissions and know what to look out for in the permissions grants. As an alternative to that, the publisher can clear the rights. So again, doing all the things that you would otherwise have to do, and can at least advance the cost rather than having you pay it out of pocket, can pay the cost and treat that payment as an advance against your royalties, so at least you don't have to have the cash. Third option, a publisher can clear the rights and you can split the cost either equally or in some other proportion, whatever you can agree to. And then finally, the publisher can clear and pay the costs, and this is more common than you might suspect, but you have to ask for it. It's a good solution, but it's not a perfect solution. Whatever you agree to, you should expect a balance of burden and control. So the party who pays the bill should reasonably expect to retain some control over the costs, and you can do this in one of two ways, either by establishing a budget or a ceiling for how much will be paid by the party who's doing the paying. The publisher will certainly do this, and you could do it as well if it's your obligation to pay for or even to advance the costs, or to split the costs for that matter. Alternatively, you, as the party paying the fee, paying the bill, could retain a veto over the final selection as a way of protecting themselves from unexpected cost. A publisher will almost certainly insist on a veto right if it's paying, but it will not necessarily give you volunteer a veto right for you if you're paying. You would have to know to ask for that. But you're not done yet insofar as dealing with the burden of rights clearance and permissions, because even if you get the publisher to agree to clear them and to pay, you've got to look a little further down in your agreement for publication to a section called Representations and Warranties. And in that section, you will have promised to the publisher that none of what's included in the book is going to expose the publisher to claims for things like copyright infringement, defamation, invasion of privacy, trademark infringement, and the like. And the publisher is not necessarily going to change this to conform with whose obligation it is. It's been agreed to clear those rights. So you have to pay attention to that, because if the publisher has agreed to take on the obligation to clear the rights, then insofar as it's the publisher that has made decisions about what they need permission for and what they don't need permission for, it's the publisher's responsibility to bear the cost of dealing with any of those. The reps and warranties are going to be typically accompanied with an indemnity obligation and has you financially responsible for resolving any of these claims if they surface. And it won't do you much good to shift the obligation to clear rights and secure necessary permissions if at the end of the day you're going to remain primarily liable for defending any claim that wasn't done properly. And if the language in your indemnity obligation says that you are responsible not only for claims but for alleged claims, then you may be responsible for defending against claims that at the end of the day are frivolous or without merit. So now to the substance. What are the potential causes of action that we're talking about here? Well, first and foremost, of course, is copyright infringement. More about that in a few minutes. Along with that, there's exposure for a breach of scholarly integrity, which is closely related to copyright infringement claim, but not the same. Defamation claims, potential defamation, libel, and slander. The potential for a violation of a privacy right. The potential for a misappropriation of the right of publicity. Potential for trademark infringement. Potential for unfair or deceptive advertising. And finally, potential for misappropriation of trade secrets. So let's take these one by one. Excuse me. Take copyright basics first. So indulge me, if you will, in a quick primer about copyright so that we can understand where the exposure for claims actually comes from. Copyright, of course, covers original expression fixed in a tangible medium. This is not a qualitative evaluation, but the bar is low, and it covers the expression, that is the original authorship, not the underlying facts or ideas or processes that you're describing, but only the particular way that you've described them. The protection is automatic and instantaneous. So the moment that that original expression is fixed in a tangible medium, saved to disk, put on paper, captured in film or on a canvas, or hit save to disk on your computer, and the copyright ownership and protection attaches automatically. Neither registration nor notice are required, although both of these things, there's good reason to use both of these things if you're a copyright owner, but they're not preconditions to your claim of copyright. Importantly, posting on the internet does not inject a work into the public domain, even if it hasn't been registered, even if there's no notice. The act of publishing it, even on the internet, does not inject it into the public domain. This is commonly misunderstood. The copyright is not a single right. It includes a bundle of 6 rights that the copyright owner has a monopoly interest in for the term of copyright. Those rights include the reproduction right, the distribution right, the adaptation right, importantly. So the right to make a work that's derivative of your work is exclusively yours unless you grant a license to somebody else. The public display right, the public performance right, and for sound recordings, there's a digital transmission right. Remedies for running afoul for exercising one of these monopoly rights without a license or without an excuse include, first and foremost, exposure to public contempt and outrage. Sometimes being identified in the public as an infringer is highly detrimental to your academic career and even to your business if it's an online business. Injunctive relief secondarily, so it could be an order from a court to the infringer to stop the infringing conduct, but also an order to seize and destroy all copies of infringing materials. And actual damages proved, so actual money damages that you can prove that you have suffered as a consequence of the infringement. That means revenue that you have lost and profits that the infringer has made, but these can't be speculative. They have to be proved with a degree of credibility and predictability. With a timely registration, you get a couple of extraordinary remedies on top of these, and they include statutory damages. So the court relieves you of the obligation to prove that you've actually suffered monetary damages, and instead can make an award without proof in a range from $750 on the low end to $30,000 per work infringed on the high end for ordinary infringement, or up to $150,000 per work infringed in the case of willful infringement. And also the ability to cover your attorney's fees and costs if you've been successful with your claim. In the Midwest, attorney's fees and costs in a small copyright matter, that is a matter with less than $1 million in dispute, has averaged around $250,000 to $350,000 for a trial through verdict. So that's not an inconsequential aspect of your remedy, and by the same token, not an inconsequential aspect of your exposure if you're on the wrong side of one of these claims. So if you want to use something that's protected by copyright, what are your options? Well, you can, since the copyright expressed the particular expression but not the underlying facts and ideas, you can extract the unprotected facts and ideas and express them in your own words. You can rely on a defense called the defense of fair use, and but that is a lot more complicated in its application than a lot of folks understand. There's a 4-factor test Each case is analyzed on the basis of those 4 factors. We don't have time to go into detail on that on this call. That could be a webinar all its own. Suffice to say, it's a topic in my book that Kim mentioned at the beginning of this teleconference, and there's plenty of good information on the subject of fair use available on the internet. You can always secure permission. In doubt, you can secure permission, or you can secure permission if you're sure you need it. And then finally, and I hesitate to say this, so I've said it only very lightly on your screen, you can take your chances. And that may sound surprising coming from a lawyer, but actually in some cases where the cost and burden of clearing permissions for works where the owner is difficult to find or difficult to get a hold of, it may in some cases be within the realm of acceptable business risk to go ahead and move forward with the use of a work that probably requires permission, knowing that in a lot of cases that a claim will never be asserted, and that if a claim is asserted, it can be settled. And so what you would do in this case is establish a reserve for dealing with these claims after the fact, understanding that the after the fact cost of a license to do what you've done is going to be more expensive, and sometimes much more expensive than the cost had you obtained the permission in advance of your use when you still had a chance to change your mind about using it. So there's another layer of rules for scholars that sounds a lot like copyright infringement, but really deals with a separate concept of academic integrity, where plagiarism is a concern, and it's not the same thing as copyright infringement. Plagiarism is about attribution. Attribution is the thing. It's essential that you, for purposes of academic integrity, not pass off the expression or the ideas of others as your own. And so credit is a key there. Credit alone is going to be sufficient for purposes of academic integrity. It's not going to be sufficient for copyright infringement claims. And fair use may get you off the hook for a copyright infringement claim, but it is not going to get you off the hook for a claim that you have violated the academic integrity or compromised your academic integrity if that's the issue. So with academic integrity, it's not just the expression, but also the underlying ideas that are protected, the underlying facts. Fair use is not going to shield you. There are different expectations in different fields of study as to who gets credit, who's entitled to credit for authorship. Authorship for copyright purposes is not the same as a consequence as authorship for purposes of scholarship. In the case of scholarship, in order to receive credit as an author in some fields, you have to not only have contributed to the written report of your research, but you have to have also contributed to the research design. Contribution to the research design by itself, however, is not going to get you authorship attribution for copyright purposes. And I think, as I've alluded to earlier, there are special terms and language for certain kinds of works. Third-party photos, for example. You need to understand and be able to discern the difference between editorial use and commercial use, because commercial use is going to cost you more. You need to understand royalty-free license versus a rights-managed license versus work that's been commissioned. Royalty-free doesn't mean that it's free. And you have to also understand that there are likely to be limitations on the use that you can make of those photographs, and you have to understand where to go to find out what those limitations are. With respect to music, use of song lyrics in a text is one way in which you might use music belonging to someone else. The music publisher, which typically owns the rights in the musical composition and the associated lyrics, will tell you that if you use a stanza or more, you're going to need permission for that, although I think the case law, and certainly I would tell you that's not necessarily the case. And in multimedia works, it gets much more complex because there you're not talking about use of one work necessarily. It might be two works. It might be that you're using the musical composition as well as a separately protected sound recording of a performance of that composition, and so you may be dealing with not one owner but two owners of two different sets of rights that you have to understand and be prepared to deal with. When it comes to art, I think overprotection is the rule. When it comes to scholarly use of art, the practice has been to secure permission even when it's likely the case that you don't need that. I've parenthetically noted a case here, Bridgman Art versus Corel, that deals with the protectability under copyright law of archival photographs of original works that long since passed into the public domain. It's not uncommon for a museum to prohibit you from taking your own image and to allow you only to use images that they have had taken by their staff photographers so that they can control the copyrights in those images as if the photograph is separately protectable. And what the Bridgman Art case tells us, if it's just an archival image intended to be exactly the same as the image that's captured, then there really isn't any original authorship there to protect and claim. Fair use is systemically underutilized when it comes to academic use of art, but the College Art Association has published a set of best practices that's trying to reverse that tendency and make more vigorous use of the fair use right. Another type of claim deals with defamation. Defamation is an umbrella term for libel and slander. It is concerned with injury to reputation. It's a matter of state law, and the law varies from state to state, but in general terms, it's comprised of 6 elements. First is an unprivileged publication. That is a communication to some other party, and in the case of libel, that needs to be only one other party, although, if we're talking about textbooks or journal articles or multimedia works used in education, publication is going to be a given, but it's not the ultimate publication that constitutes publication for libel purposes. Your delivery of a manuscript to your editor, one other person, can constitute the publication that creates exposure for a libel claim. That publication is of a defamatory statement of fact. That is a statement of fact that tends to injure one in their business or profession or expose them to public scorn, contempt, or ridicule. A statement that's false, that is of and concerning an identifiable living plaintiff. That's an important word there, living plaintiff. The law is not concerned with protecting the reputations of dead people. That causes damage to the plaintiff's reputation, and finally, that's made with the requisite degree of fault. So there's no, unlike copyright protection, there's no fault liability for defamation. At minimum, you have to have been negligent in some respect, and with certain kinds of plaintiffs who are public officials or public figures, the standard is higher. They have to establish that you acted with actual malice, something called actual malice. For a defamation claim, all 6 of these elements have to be present. If any one of them can be knocked out, then the defamation claim goes away. So, if we can knock out this first element, unprivileged publication, well, publication we're not going to be able to get rid of, but there are some kinds of publications that might be privileged. For example, reporting on the statements in a court pleading or in a courtroom or in the legislature is subject to a privilege, as long as your report is a fair report of what was said there, even if it turns out that what was said there is otherwise libelous. It has to be a defamatory statement of fact, so there's really two components to this. First of all, it has to be injurious to reputation, that's the defamatory part, and it has to be a statement of fact because opinion is protected by the First Amendment. So if what you're saying is opinion, that's going to be protected, even if it's unflattering. If it's a statement of fact, that's where you have to be concerned. Importantly, you can't convert a statement of fact into opinion simply by saying, in my opinion, Joe Blow was convicted of 6 felonies, because that's clearly a statement of fact, notwithstanding the fact that you prefaced it by attempting to characterize it as opinion. Certainly, if you can establish that a statement is true, then, and that's substantively true, then you don't have a concern, because falsity is required. If you can knock out the identifiable living plaintiff, so either the plaintiff is not alive anymore, or you so characterized them that they're no longer identifiable. That is not. Changing the name is not necessarily sufficient if in your description you have included enough facts so that one other living person could identify them. There has to be damage, of course, to plaintiff's reputation. You have to prove that, and it has to have been made with the requisite degree of fault, at least negligence. Some things about defamation. Juries tend to be sympathetic to plaintiffs, and so the media loses at trial in 60% of the cases. Verdicts are reversed or reduced on appeal because the juries tend to be overly sympathetic, but the cost is not recovered. So the cost of your success, you're not going to recover, and the cost will almost certainly be in the 6-figure range. Even where there's insurance, and if you're the author, even if you've been named as an additional named insured on your publisher's policy, the first $50,000 to $300,000 of expenses is probably going to be a deductible that you would be responsible for anyway. And if your indemnification obligation is triggered by an allegation as opposed to the final and non-appealable verdict of a court of competent jurisdiction, this is probably going to be your check to pick up. Invasion of privacy. Here, the concern is not with injury to reputation, but instead with outrageous or highly offensive conduct, causing emotional upset or distress. This type of claim is also based on state law, so it varies from state to state. There are 4 forms of invasion privacy claim, and not all states recognize each form, but they are the one that you would first think of, publication of private facts. Another, intrusion into seclusion that might not occur to you. This is not so much about what you publish, but about how you gather the information by prying into places where you don't have permission to be, or using a hidden camera or a hidden microphone. There are false light claims, which are a lot like defamation claims, except that the injury being redressed here is not injury to reputation, but offense, great emotional upset and distress. And then finally, misappropriation of the right of publicity, which we'll talk about now. In about half the states, this misappropriation of the right of publicity right is a property right that's transferable and that survives death. In the other half of the states, it's a personal right and it dies with the subject. It involves the unauthorized use of somebody's name, likeness, or persona. So it's not just a name, but it can be a photograph, it can be a signature, it could be a catchphrase, anything closely associated with a particular individual. It might even be a signature song, for example. It doesn't require for-profit uses, but only promotional uses of an unrelated product or service. So you're using somebody's name to promote a product or service that they haven't endorsed and that they're not associated with. In our context, it comes into play with respect to book blurbs and testimonials and with unauthorized biographies. Another type of claim involves trademarks. A trademark is a distinctive source identifier. There are two interests protected here. The property right of the trademark owner, so that is the protection for the investment that they've made in creating goodwill associated with their particular brand. And also the right of the public not to be confused as the source. So two fairly different constituents here that are entitled to trademark protection. There is an exception called a fair use exception that's different from the fair use that we talk about in a copyright context, in a trademark context, because trademarks can consist of ordinary English language words. Take American Airlines, for example. There are two ordinary English language words there, but they serve as a brand for a particular airline travel services. But fair use would say that because those are ordinary English language words, American Airlines can't take them out of the English language. And so you have a fair use right to use those words as in the context of their ordinary meaning in a sentence, for example. You might say that Delta is an American Airlines in a sentence, and as long as it isn't used in a trademark sense or in a sense that creates a likelihood of confusion in the minds of consumers, it's going to be protected. There's a different kind of fair use called nominative fair use, which says that you have the right to use American Airlines to identify travel services that come from the company known as American Airlines. In other words, you can use that name to identify the provider of services under that brand. And there's a distinction between claiming rights in the trademark, claiming rights in a series title, for example, as opposed to avoiding infringement. The threshold is different for each of these things. Different sets of rules apply. When it comes to book titles are, there isn't sufficient authorship there for them to be protected as a copyrighted work. That is for the title itself as opposed to the book. There is the potential for trademark rights under certain circumstances, and there is certainly the potential for your book title to infringe somebody else's trademark. If your book title were Microsoft something, you might well find yourself on the wrong side of a trademark infringement claim. So, back to our image. First question I have for you, is the photo protected by copyright? And the answer here is, of course, yes. Photographs are copyrightable subject matter, and they are protected. In this particular case, if we had run across this photograph on a website, it might or might not have an attribution associated with it, depending on whether the place where you found it was using it in accordance with license terms or had grabbed it from someplace else and was using it without permission. We can do a search, however, for this image and discover, if we do so, doing a search for Trump plus Pope using Google image search, we find this image on a Associated Press stock photography site. Drilling a little deeper, we see data about the image and its source, that it was created on May 24th, 2017, that it was taken by photographer Evan Vucci, that the source and credit line is for Associated Press, and that it was taken at Vatican City. You may not have noticed, but in this photograph there is also a painting in the background, and the question is, do you need permission for that as well? Let me go up here to show you. You can see right here is a portion of a painting. And the answer is no, you don't need permission for that painting. As it happens, that image is entitled, it's a Italian Renaissance oil painting created by Pietro Perugino in 1499. So it's from Italy, and any copyrights in that image have long since expired. It's called Resurrection of the Christ. But if it were not so old an image, if we could establish that it was published after 1923, then we would have to be concerned that there is still copyright protection for that image, and we would have to do a fair use analysis of that image and the way that it's used in the photograph to know whether or not we also needed permission not only for the use of the photograph, but for the use of the oil painting that appears in the background. Have I avoided an infringement claim by altering the image? In other words, have I made it by my own by making a change? Right? And the answer is no, I haven't, because the right to make a derivative of the original work is one of the rights that belongs exclusively to the copyright holder. So at the end of the day, I cannot make enough changes to this photographic image to make it my own so as to avoid an infringement claim. Have I possibly created other issues by altering the image? And the answer here, as you might suspect, is yes. I've created a potential defamation claim if I've wrongly implied from the thought bubbles that I added to the image that the Pope was not pleased to be there, although when it comes to defamation claims, truth is an absolute defense. If I get a royalty-free license from API, which is the source where that image came from, is my use here covered? And the answer, you might be surprised to learn, is no, because probably the license that I got from Associated Press would not let me make the adaptations that I made. And in addition to that, it's likely that other clearances from the subjects depicted in the image were not obtained by the Associated Press, depending on the sort of use that I want to use the image for. Does my alteration of the image make it now a fair use as a protected parody? Here again, the answer might surprise you, no, because this is not a parody, this is satire, and satire is not protected by the First Amendment. The use of humor, irony, exaggeration, or ridicule to expose and criticize a thought is satire. Parody, on the other hand, is imitation with exaggeration to criticize the work imitated. And here, my criticism is of the subject in the photo, not of the photo in the photographer's style. So it's not parody, not protected by as a parody by the First Amendment. Does it matter that I'm not being paid to give this presentation? Here again, the answer might surprise you. The answer is no. Receipt of money is not an element of a copyright infringement claim, although it may come into play as to damages or as to a fair use defense. And then finally, am I worried about being sued? And here, I'm just going to leave this question hanging and not answer it in a public forum. I think it's time for questions, Kim.
Okay, thanks, Steve, for that excellent information on rights clearance and permissions. We do have questions. If you have a question, please type it into the question section of your control panel, and I'll be reading the questions to Steve. So the first question is, there is a lot of 2D graphic art whose creator has been dead for centuries. Frequently, these works are held by museums, libraries, archives, etc. These days, these groups are digitizing these works and making them available online. The question is, to what extent these digital images are protected? Copyright public domain books typically cite a federal district court decision somewhere in New York, but go on to mention that it was appealed to the circuit court. Can the speaker comment about the status of such images? Unfortunately, recently some of these online images have had steganography, normally invisible marks, to their images in order to assert ownership not to the original but to the marks themselves.
Okay, well, yeah, that's a long question. A lot of subparts there. First, the case that was referred to, the New York case that was referred to, was the Bridgman case that I referenced earlier in the presentation. And what the Bridgman case said was that an archival image of an otherwise unprotected work of art is not going to be separately protectable as a photograph because there's no new original authorship there. That's one case because the issue doesn't often get litigated. It would suggest that there isn't a copyright claim for archival images of works that are otherwise in the public domain. But a copyright claim is not the only kind of claim that can be made. So images that are in a private collection, even if they're public domain images, if your only access to them is through that private collection, then the collection can condition your access on agreement to certain terms, and those terms might include that you not take photographs of the images for other than your personal private use, home use. And in that case, what you end up with is a breach of contract claim, which is not going to be as difficult or as potentially doesn't expose you to the same sort of risk that a copyright infringement claim exposes you to, but it is a potential claim. If you can get access to the image as used by somebody else, so that you don't have to reach agreement with the private museum or gallery, then you won't, of course, have that exposure for a contract claim. Steganography, that's a digital technology that allows a digital, essentially the equivalent of a digital signature or fingerprint, to be buried in an image in a way that can't be detected or removed, and so it serves as the smoking gun that the image that you used is the image that you obtained from that particular source. Are there follow-up questions or other questions?
Okay, she said, for example, the French National Library has a particularly nice copy of Shu Enron, which is an illustrated early modern Japanese work, which is at least over a century old. The original work on which the French copy is based dates to the middle of the 16th century. Okay, well, again, it's going to be in the public domain. You can expect that the museum is going to claim copyright in the photograph. Whether they would be successful in asserting that claim is open to question. All right, thanks, Steve. The next question is, I am working on a book that highlights historical sources. If these are published materials rather than those that are in an archive, and I quote the text substantially with proper attribution, citation, are there any issues to which I need to be attentive? Well, it's a copyrightable work, and you're exposed for copyright infringement unless your use qualifies as a fair use. Attribution is one component of establishing fair use rights, but there are 4 factors that have to always be considered. What's the nature of the work that you're using? Is it a highly creative work that gets a lot of protection, or a fact-intensive work that doesn't get very much protection? What's the nature of your use? Is it for commercial purposes, for-profit purposes, or is it for not-for-profit educational purposes? What is the amount and significance of the material that you've taken? Very short extracts are not typically going to be problematic, although it would be, it all depends on the nature of the source work. If it's a haiku, you're not going to be able to take very much of it without crossing the line. On the other hand, if it's a 80,000 word work on research on a socially significant issue, you might well be able to take a 7,000 word extract if your purpose is
criticizing the conclusions of the original author. And so it all depends. And then finally, the fourth factor is the impact of your use on the value of the underlying work. And in each case, all four of those factors have to be taken into account. So without knowing a lot of specifics, I can't really opine as to whether that particular use that was described is going to qualify as a fair use or not.
Okay, this is kind of a slight follow-up to that. Is it correct to say that works published during and before 1923 can be used without permission?
That's true today. It's not going to be true as of January 1. That's for 20 years, 1923 has been the magic year. But as of 2019, the year will become the year that's important will become not 1923 but 1924, and thereafter that year will roll 1 year every calendar year.
Okay. So again, if you have any questions, please type them into the question box on the control panel on your screen. The next question, doesn't my contract with my publisher cover permissions?
Well, it does, and probably what it says is that you're responsible. You're responsible for doing the work, you're responsible for paying the cost, and if you do it wrong and the publisher gets a claim, even a claim alleging that you did it wrong, whether you did or didn't, you're probably going to be responsible for defending the cost of defending that claim.
Again, thank you, Steve, for sharing your expertise with us, and thank you all for participating in today's presentation.